I'm Catharine Langley, barrister at Westgate Chambers, and this is the Family Law Week's Bitesized video collection. This topic will cover how to prepare a position statement in financial remedy proceedings. So, of course, with any position statement, the first aspect that we want to start with is the court that we're sitting in, case number and parties' names. We move to the introduction, where, of course, we have who we are, who we're instructed by, and our opponent. In particular for FDR position statements, you want to have if there are any open offers or if there haven't been. That's always a good indication to put in the very top, in particular for an FDR position statement, if there haven't been any offers at all. And then, of course, special measures as relevant will also go in the introduction section. Now, coming to the background, some important aspects that you want to cover are parties' ages. The court wants to know if the parties are similar in age, especially when considering any sort of pension sharing orders. You want to look at addresses, so long as they're not confidential, length of the marriage, any sort of NCDR attempts, if there have been, or if there are exemptions, that's always good to highlight in the background, and if there have been any agreements. So, for example, sometimes when you come to an FDR, indeed, hopefully by the time, if you are going to a final hearing, there will be some agreement as to figures and to facts and circumstances. So that's always helpful to just record this figure's agreed, the date of the order it was agreed, or when, if it wasn't in an order, when it was agreed. Moving on then, we come to look at the main body of the order. Now, that's made up of a few categories, mostly governed by Section 25 factors for the most part. We come to look at assets. Now, when looking at assets, you want to focus on properties, any land owned, any sort of objects. So that can include, for example, cryptocurrency. That is also being, well, that's more considered a chattel, but we'll come on to those in a moment. Generally, you want to be looking at core assets that each party has. We then come to look at the health. If there are any health aspects by either party in terms of anything that could detrimentally impact their health, or if they are in fact good health, all of that is relevant information when considering a departure, if that is your case. We'll then be looking at mortgage and income raising capacity. That will more so be focused on, do the parties have any mortgage raising capacity at all? What are their incomes? What are they likely to make in the future? Are they retired, for example? All of that information will, of course, be relevant. And it's helpful to have a section in the position statement that just extracts that information from the Form E and just sort of consolidates it at a glance, where we can see what each party earns and what properties they have in terms of moving forward. Coming to look then at housing needs. Now, housing need is, of course, decided based upon if there's any minors, any dependents, the type of living that they've had, if you're looking at a needs case, for example, any children. So all of that will then need to be addressed underneath. I then personally turn to look at liabilities. And I think that's a really important thing to focus on in a position statement, to look at any debts. You want to look out for any debts owed to lawyers, any legal fees, any hard debts, and if there are any soft loans, what you say they are and why you say they're relevant. If your case is to seek a departure from equality, you want to address it here. Or alternatively, if you seek to run unmatched contributions, or if you're running a conduct argument, that of course would need to be flagged at the first hearing, but you would equally want to address it at this point in your position statement, whether it be prior to an FDR or indeed final hearing. I then like to deal with offers last. Now, it is normal for offers to be put forward at the FDR just prior to the FDR. So most relevant, it would be in the FDR note or indeed any final hearing note. You just want to detail. I think it's always helpful to have a schedule or a sort of table that will detail what each party has put forward. If there are any agreements, a little box that says this is agreed, this remains unagreed, wife's position, husband's position, and that just nicely helps illustrate in a neat table what assets are agreed to either be shared or given to wife, given to husband, and which ones remain in dispute. And that can also help with pushing parties for a final order at an FDR. Turning then to, I always address directions, and I think is helpful. It helps put puts both parties' perspective at the forefront in terms of settlement, if you're talking about directions for a final hearing and the costs involved. So I would always have directions at the very, very end. And of course, if there are any updates or anything of any relevance that are important, that would always go right at the top, or equally right at the end. And of course, never forget to put your name, who you represent, and the date. And that is how I would structure my position statement, whether it be for an FDA, FDR, or final hearing. Thank you.